So needless to say, 65 and coverage Friday. We
(7:03). Would the recording secretary please conduct the roll call?
Commissioner Kuznick,
Present.
Commissioner Marks,
here.
Commissioner Wallace,
I'm here.
Vice Chair Edwards,
Present.
and Chair Alpert.
He's absent for the evening.
Yep.
All right, item number 3 is the Pledge of Allegiance. Please join me. Item number 4 is public comments or written communications. At this time, members of the public may address the Planning Commission on any item not already included on tonight's agenda. If you would like to speak, please fill out a green speaker card located in the back of the room and submit it to the recording secretary. If you are participating remotely, you may click the raise your hand button on your computer or *9 on your telephone to request to speak when public comment is being taken. Are there any late communications, speaker cards, or any speakers in our Zoom audience?
No late communication was received, no speaker cards, and no hands raised on Zoom.
All right, then Madam Recording Secretary.
Not for this item.
Not for this item. Okay, thank you very much. So we've got no public speakers, so we'll close the public comment. Item number 5 is additions and revisions.
We have none tonight.
Thank you. Item number 6 is our consent calendar. There are none. Item number 7 is approval of the minutes. Those are the minutes from the December 6th, 2022 regular Planning Commission meeting.
I'll move approval.
I can second the motion.
All right, the item passes. Item number 8 is continued items after closing of the public hearing. There are none. Item 9 is continued items. There are none. Item 10 is the public hearing new items. There are none. Item number 11 is the non-public hearing action items. There are none. And then item 12 is our study session, commissioner liaison report, and interest items staff report. Item 12.1 is the policy discussion, general plan, zoning consistency determination under the Housing Accountability Act. Mr. License, you have a staff report?
Yes, thank you and good evening, Madam Vice Chair and the members of the commission. At a previous commission meeting, the commission asked staff to put together a presentation on general plan and zoning compliance for SB 330 applications. Specifically, the commission asked staff to do a presentation on whether the decision should be made at staff level or whether that decision should be made discretionary by the Planning Commission. I see Commissioner Wallace shaking his head. Do you have a correction to that?
Yes, the issue that was presented was not that. The issue that was presented was whether under our current rules, the decision of compliance with a proposed housing project with our city standards, whether they be general plan, specific plan, zoning ordinance, or otherwise, who gets to make that decision now? The issue of changing it is irrelevant until you get to the point of who makes the decision now. And that was the issue that we discussed in detail on the October 18th meeting last year, and that I personally discussed with staff on several occasions after that. The question wasn't whether who should do it, the question was under our current rules, who does do it?
Okay, I think we'll be answering that question as well as a part of this presentation. So as we mentioned in the staff report, just about every city that we know of puts this decision in the hands of staff. However, we did bring in a couple of experts on the matter of SB 330 from the law firm of Burke Williams and Sorensen, and here to do a presentation. Before I turn it over to Eric Phillips, they did attach to the staff report their own report on the matter and opined on it. We've also attached to the staff report a report by Commissioner Wallace, and we've just received here on the dais some further study from Commissioner Wallace that I don't think that staff has had an opportunity to review as yet, but we'll try to do so as the presentation goes on. And with that, I'm going to turn it over to Eric Phillips from Burke Williams and Sorensen, and he'll be giving a PowerPoint presentation on this.
Great, thank you. So good evening, Vice Chair, Planning Commissioners. Thank you for having me here this evening. As City Attorney License was just explaining, I worked on this material with my colleague, Tom Brown. Tom and I are both lawyers at Burke Williams and Sorensen. We are primarily a municipal law firm. Tom has long experience working in municipal law in both trial court and appellate work, and long service with the League of California Cities, now Cal Cities organization. I'm a partner in the land use and real estate group at Burke Williams and Sorensen. So my practice focuses almost entirely on land use, on housing development projects, on CEQA work. I also litigate these matters at trial court. Recently had a case at the Court of Appeal, and I'm a frequent presenter on these topics, both for the League of California Cities and for the American Planning Association, where I just finished a 4-year term on the board. So hopefully our insights that we have into the housing laws that we're going to talk tonight will be useful for you and for your discussion. And I'm going to go through an overview of some key terms that we wrote about in our memorandum, and then open up the floor for any questions and discussion and any other insight that I can help provide. But as we've framed it, the key questions for discussion are who should be making the compliance determination for future applications under the Housing Accountability Act? Is that an administrative function that staff should continue to do, or should there be a policy where this authority would be under the commission's jurisdiction? And we'll talk a little bit about how that works in current practice and why we think it should work as we're recommending to not change the policy and actually maintain the status quo where staff conducts the initial determination of compliance with objective standards under the Housing Accountability Act. And then ultimately the Planning Commission conduct its review of the project and make its findings and of fact and take action on the project when the time is ripe to do so. And the memo that we provided that's included in the staff report goes through our thinking and rationale for this for a number of reasons, but really at the highest level is that we have a concern that should there be a discretionary review of standards that are really intended to be objective, that it would invite legal challenge and it could expose the city to severe legal risk under state housing laws. And I want to then spend a little bit of time talking about what that legal framework looks like, because there have been a lot of changes in state housing law over the last 5 years that have dramatically changed the landscape of how cities do business and how they review their projects. So it's important that we're all starting from the same point of reference when it comes to that, and then making decisions for how we'll process projects going forward. So when we talk about state housing laws, a lot of people will talk about SB 330. What that really refers to is something called the Housing Crisis Act. In 2019, the legislature adopted Senate Bill 330, which was called the Housing Crisis Act. And it was a very lengthy bill. It had 16 individual sections, all of which were designed to curtail city discretion around housing development project and limit the ability to restrict housing development, really trying to encourage approval of housing development projects. After SB 330 took effect, it was extended by the legislature through a bill called SB 8. But right now it's the law of the land through at least 2030. It's a 10-year provision. So some of the things that we're going to talk about are part of the Housing Crisis Act that are only in place for the next 10 years unless the legislature extends it. Some of them were in place even before the Housing Crisis Act, and I'll highlight which ones those are as we're going through. But the Housing Crisis Act and SB 330 is definitely the impetus for the discussion that we're having here tonight. But the main restriction that's included in SB 330 and the main body of law that we're going to talk about is actually the Housing Accountability Act, or the HAA. And this is a provision of the government code that actually predates SB 330. Many of its provisions will continue after SB 330 sunsets. But what the HAA says, it is designed to protect all housing development projects, affordable projects and market rate projects. And a housing development project is defined as a project that has only residential uses. If it has transitional and supportive housing uses, it qualifies, or if it's a mixed use project where at least 2/3 of its square footage is for residential use. All three of those types of projects are housing development projects, and regardless of their level of affordability, they're covered by the HAA. And what the HAA says is that if a housing development project complies with objective standards, then the city can only reduce the density of that project or deny that project if it makes very specific findings. It has to find that the project would result in a specific adverse impact to public health and safety, and that that impact can't be mitigated in any way except by denying that project or by reducing its density. So the key crux here is, does a project comply with objective development standards? There are additional protections in the HAA for projects that have at least 20% of their units as affordable to low-income households. Then there's even further findings that would have to be made if the city were going to deny or condition that project. But for the bulk of our conversation, what's really important are these objective standards. And again, that applies to all projects regardless of their affordability. But before we go any further with this, I think it's important to spend a little bit of time to understand exactly what is and what isn't an objective standard. And the memorandum that's in the staff report goes into this in some detail. We have an attachment that gives some examples, but I do want to spend a little bit of time talking about this concept here as well. SB 330 includes a specific definition of what is an objective standard. And that means that the standard involves no personal or subjective judgment. It has to be uniformly verifiable, and it has to be both available and knowable in advance of an application. So that's a pretty narrow definition, and it really gets at the heart of what makes these housing laws work, is that a standard has to be pretty close to inarguable. So an example of an objective standard is height. If you have a 40-foot height standard, you can go out and measure whether the building is 40 feet height. If you can look at the plans and tell whether something is going to comply with that or not. There's no discretion necessary to determine whether or not the building is tall or too tall. Setbacks, lot coverage, open space requirements, density limitations, floor area limitations, all of those hard number type standards that you have in your development code are examples of objective standards. And the sources of objective standards can come from your general plan, your zoning code, subdivision standards, any other policies that the city has adopted. But the key is that they have to be written and in effect in advance so that both the public, the decision-making bodies, staff, and applicants can look up and know what rules they're going to be subject to before they ever even submit their application. So that way people have their expectations set in advance, whether this is something that can be approved or not. So then by contrast, a standard that is not objective or a subjective standard is almost everything else. And frankly, it makes up the bulk of most planning codes, most general plans, most specific plans. Planning practice in California for years and years and years have focused on non-objective standards and a lot of discretionary decision-making vested in planning commissions, city councils, and other review bodies. And the Housing Accountability Act really looks to limit that practice and change how planning work is done here in California. So I've put some examples up on the screen. There's other examples in the memorandum itself, but the general theme are things that are more qualitative or that different people could look at a standard and reach different conclusions are not sufficiently objective. So the quotes that I have here on the slide are quotes that come from actual jurisdiction zoning codes and standards that in the past could have been used to approve or deny a development project, but under the HAA are no longer fair game. I also want to highlight a couple of elements from case law that further flesh out this idea of what's an objective standard and what's not an objective standard. There's a case, it's called Honchru versus the County of Stanislaus, which involved a subdivision map for a residential community. And the MAP Act, which governs the approval of tentative maps, includes mandatory findings that cities have to make when they're approving a tentative map. One of those findings that's mandated in the statute is whether or not the site is physically suitable for the proposed development. But under the HAA, that doesn't meet the definition of objective. So the Court of Appeal has said that even though that's a mandatory finding, the city or the county in that case can't deny a project on that basis. So whether or not it finds that it is or is not physically suitable for the proposed development, it doesn't provide a legal basis to deny the application or reduce the density of the project under the HAA. A more recent case was the Carla versus City of San Mateo case, which was decided here in the First District Court of Appeal, where the City of San Mateo was applying its design guidelines to a housing development project. And the standard at issue there was a transition standard. It was a height standard in their development guidelines. And it said that when a multi-story building was next to a single-story building and there was more than two-story height differential, so far pretty measurable, pretty objective, they said that there had to be an adequate transition from the one building to the next. And there was no way to objectively determine whether or not the transition was adequate. There was contrasting evidence in the record in that case. Staff and the applicant's architect evaluated the project and felt that the landscaping transition and the partial step backs that the building used were a suitable transition and made that an argument, presented that analysis. Ultimately, the city council disagreed, denied the project, but the court overturned them and said that it was not a reasonable, sufficiently objective standard or a legal basis to deny the project because the standard didn't meet that objective definition that we were talking about. The other thing that the court said in that Carla case is that standards that require any sort of interpretive gloss or any sort of personal decision-making about how to apply that standard aren't subjective. So almost by definition, if two people can disagree about whether or not a project meets a standard, that standard isn't going to meet the objective definition. That if it requires a decision-making body's interpretation and discretion to know how to apply or whether a standard should apply, then that standard isn't going to be applicable for denying or reducing the density of a project. HCD has also provided a lot of guidance on this topic in terms of what are or are not objective standards. I don't want to repeat all of that. A lot of it's in the memo too. But if there are questions, we can come back to it. The last one I'll point out though, before we move on, is that one of the specific examples that HCD has identified are for standards that would require subsequent discretionary approvals. Like for example, a lot of jurisdictions will designate an area for mixed use development in their general plan and then say that we are not going to approve development until we've adopted a specific plan for the specific development about how that mixed use project is going to go forward. But that standard to have a specific plan is not an objective standard because to adopt a specific plan involves the use of discretion, you could be creating all new development standards. So until that specific plan is actually adopted and those development standards are defined and objective and applicable, you can't rely on the standard to just prepare a specific plan as a basis to deny a project or reduce its density. So shifting a little bit now that we've talked about those terms, from what is an objective standard to how they're used, the application process under the SB 330 and the Housing Accountability Act has been changed. It's different than it was even just a couple of years ago before the Housing Crisis Act took effect. So now the process is that first an applicant will submit their application. The city has 30 days to decide whether or not that's a complete application, whether or not it has provided enough information for the city to evaluate. The city will provide in advance a checklist of completeness items, and then it really is limited to everything that's on that checklist when it's evaluating for completeness to understand whether or not the application has provided enough information to evaluate. After that completeness determination happens, then the HAA requires that the city provide a written determination of any inconsistency with objective standards within 30 days or within 60 days after the project has been found to be complete. The 30-day timeframe applies for smaller projects at 150 units or fewer. You have 60 days to do so if the project is more than 150 units. The important limitation on this analysis, however, is that the determination is limited to any fees or standards that were in place when the developer submitted their preliminary application. So under the Housing Accountability Act and SB 330, an developer gets the benefit of the rules that are in place when they come in with their application. So any standards that are adopted later can't be applied or used to evaluate the project. It's limited to what's in place at the time. But I want to come back to the written determination, because that's kind of the crux of what we're talking about here tonight. As was alluded to during the opening of the conversation, the opening of this part of the meeting tonight, a project can be deemed consistent by matter of law under the HAA if that time frame for providing written city comments isn't complied with. So again, we have 30 days or 60 days from when an application is complete. If the city does not provide written notice that a project doesn't comply with those objective standards in that time frame, then the project could be deemed consistent with those standards. So that would mean that a project that didn't actually comply would be treated as though it complied as a matter of law. But that's not the only way that a project can be deemed consistent with standards. The HAA also changed the standard of review that's used for housing development projects. Specifically, it says that as long as there's substantial evidence in the record that would allow a reasonable person to conclude that the project is consistent with a standard, then it shall be deemed consistent with that standard. And that's part of what happened in that Carla versus San Mateo case that I talked about before. There, both the applicant, their architect, and city staff had provided some analysis that explained why they thought the project was consistent with the standards that were at issue. And the court said that that was enough, that the analysis that had been provided there was enough that could convince a reasonable person that it was consistent. And so in some ways that takes that calls the question and takes the decision-making authority away from the city at the end of the day. The city still gets to make the findings of fact, still gets to decide whether the evidence is substantial, whether the arguments are good enough. But if it ends up in front of a judge, a reviewing court, the court doesn't have to give any deference to the city as the finder of fact in that situation. And that's a huge change in how business has been done here in California. Ordinarily, when a city uses its discretion or is applying rules that it adopted, when it goes to court, the court will just look and say, what the city did reasonable? Is there any evidence that could support the city's own determination? And if there is, we're going to give the city credit that they got it right. They're the experts. They adopted their own rules. They know how to apply them. But that's not the way it works anymore under the HAA. Under the HAA, if the city is going to deny a project or reduce its density, its findings have to be based on a preponderance of the evidence, which means more evidence. It has to outweigh any potential counter arguments. And because of that reasonable person standard, there's the city's determination is not the final word. The applicant themselves can put evidence in the record. And as long as that's reasonable, then the court can and should defer to their interpretation, even in favor of the city's own interpretation of its own standards. Another little piece about that reasonable person standard that I want to highlight before we move on is that it also is a way that the court would use to judge the city's own actions in the city's own interpretation. So if the city, for example, has a long track record of applying a standard in a particular way, that is maybe good evidence to show that that is a reasonable interpretation, that interpretation should be continued. But if the city is making an ad hoc decision and changing its past practice, then that would argue against the city's decision being reasonable, because all of the other projects that had been approved under the city's former interpretation is likely going to be viewed as a reasonable interpretation of that standard. So there's a couple of different ways that these standards kind of box in the city when it's using its discretion in reviewing housing development projects. And this is actually the big reason why we think it makes sense for the initial review of consistency with objective standards to be done still at the administrative level rather than in front of a deliberative body. Because if there's room to debate and discuss and interpret a standard, that standard isn't sufficiently objective and can't be used as a basis to deny or reduce the density of the project anyway. So opening that up to a hearing is only going to invite questions about how standards actually apply and could end up getting the city in trouble under the HAA. Another limitation that the Housing Crisis Act and SB 330 put on the review process is that now no more than 5 total hearings are allowed for housing development projects. And that includes to continuances, it applies to appeals, it applies to study sessions held about projects and discussions about projects. And that's a hard limit of 5 total hearings. So if there were to be an initial consistency hearing, there's one that maybe that initial consistency determination is appealed to city council, that's 2. Then it comes back to planning commission, that's 3. Right off the bat, before we've even gotten to any CEQA meetings, any actual actions to approve the project or make its full findings that the planning commission ultimately would do. So the hearing limitations definitely pose a constraint on having these kind of intermediary hearings and project reviews. And then one of the last things I wanted to highlight is the consequences of judicial review. We talked about some of the standards that a court would use if a project ends up being challenged under the HAA. But I did want to just highlight that HAA has created very broad rights for people to challenge city determinations if they're not approving housing development projects. An applicant, a potential resident, or a housing organization all have standing to file suit. And the court is directed to order compliance with the HAA within 60 days. Eligible plaintiffs are able to recover attorney's fees. So these are lawsuits that get very expensive very quickly. And then that's before you even consider the fact that continued non-compliance with court orders can yield significant fines at the very extreme end, up to $50,000 per unit improperly denied. So there's serious legal risks that go along with not complying with the Housing Accountability Act. And again, we're just concerned that inviting additional hearings to discuss what should be objective standards could misset expectations or create opportunities to run afoul of those limitations. But it's not all bad news. There are some, I just want to highlight as I finish, some areas where there is reserved authority here for the Planning Commission. The first is CEQA, the Housing Accountability Act, makes clear that CEQA still has to be complied with when you're reviewing and taking action on housing development projects. It's not preempted. And that even that Carla versus San Mateo case was something that the court called out, where the city, in particular, the Planning Commission, ultimately the City Council, has the discretion to decide whether adequate analysis has been done and how CEQA is complied with. The other area where the Planning Commission continues to have authority is when it's adopting conditions of approval. There are limitations on conditions of approval. I just talked about all the different ways the city's discretion is limited. However, the HAA does allow for adoption of conditions of approval that are consistent with meeting the RHNA and that don't reduce the density of projects. So even if a project is consistent with objective standards and the HAA mandates approval in most cases, unless you can make those narrow health and safety findings, the Planning Commission still is charged with making the ultimate findings to approve the project and adopting conditions as might be necessary, as long as those conditions comply with the parameters that are established within the HAA. So there still is an opportunity, even after these initial consistency determinations have been made, for the Planning Commission to weigh in and be involved. So that leads me here just to my final slide as I sum up. As hopefully was clear in the memo that Tom and I worked on and the summary that I provided tonight, we think that there's lots of good reasons to continue the practice of having staff do the initial review, provide notice as specified under the HAA, and then ultimately bring projects before the Planning Commission when it's time to review those and when the time is ripe. I do want to highlight the fact that the initial staff determination about consistency with standards is standard procedure across California cities. That we included a table in our memorandum where we reached out to cities all through Contra Costa County and confirmed that this initial decision-making process, this administrative 30-day or 60-day notice, is uniformly handled at the staff level. It's not something that a hearing is scheduled to review. We did also confer with staff who did even broader outreach, talk to cities and counties that go even beyond Contra Costa County. And full disclosure, we did find one jurisdiction where they are considering a policy to have larger housing development projects with more than 50 units come forward before the Planning Commission. However, that is not a final policy, and it's our understanding that they're, for many of the same reasons that I've been talking about, that their city attorney is recommending against taking that action. So we'll keep you updated as that evolves, but definitely the trend is that the initial evaluation, first its completeness, then its consistency, that's all handled at the staff level. And then the ultimate decisions about plan consistency, CEQA conformance, conditions of approval is brought back before the Planning Commission. The other reasons, again, that can underlie our thinking as to why the process should continue to work this way is that the additional hearings not only take up staff time, it takes up your time to look at projects before they've been fully vetted, before they've been fully baked, before they've all been thought through. On one hand, maybe that sounds appealing, an opportunity to influence a project or shape it early in the process. But because of all the limitations on the city's discretion, I really do think that would lead to more questions about the proper standards of review and if there, again, there were appeals and those appeals maybe were even challenged by court, some of those are novel legal issues that haven't made their way all the way through the courts to understand exactly what the city can and can't do in that circumstance. And when we don't have the benefit of precedent, there's just confusion and the opportunity for more legal risk and exposure that we're trying to limit. I talked a little bit about the 5 hearing limit. Not only is that a practical limitation on the ability to hold hearings, there's the policy undergirding that is to try and streamline the review for projects and not draw out the development review process. And finally, I mean, I spent so much time talking about objective standards, but again, the animating principle here is that if a standard is truly objective, there won't be any need to hold a hearing and deliberate and debate whether the project complies or doesn't comply. If you need to use that amount of discretion, then the standard's not objective and not really subject to the rubric that we're evaluating projects with to begin with. So to the extent that there are concerns about how new development is going to occur within the city and wanting to make sure that you can influence how that happens and shape the way that development looks and functions, the best way to do that is to develop more robust objective standards, set those expectations up front, and so that you can provide very clear direction to staff, to the public, and to applicants in the future about how projects are going to develop here in San Ramon. And that's, in our view, the most efficient way and the most legally defensible way to handle the question of setting development standards and evaluating projects going forward. So I'll leave it there. Happy to go back and answer any questions or provide any additional information that would be helpful.
All right, thank you. Are there questions for staff or council?
Yes, but Eric beat me to it, so.
Actually, I haven't said anything yet, but does your question include questions to the speaker?
Yes.
Okay, I do have a question or two. Sort of like the famous last question.
All right, proceed.
Hi. It's nice to see another Eric standing up there.
Yeah, we have a good
and I will,
kinship right off the bat.
and I will do my best not to call you Eric, because then it would seem like there's an echo in here.
We won't know which one of us will answer.
That's right. First disclaimer. I don't claim to be a land use expert or a municipal law expert. I'm just a simple litigator. So please forgive me if I betray an abysmal ignorance of the law relating to the Housing Accountability Act. So let's start out with some simple stuff. At least it's simple to me. The first question is, I didn't see any discussion in your memo or in your presentation tonight that analyzes what the current status of San Ramon's rules are regarding which body makes the decision whether a project is consistent with the city's general plan, specific plan, zoning ordinance, or otherwise. Am I correct?
That's correct. Yeah, we did not dive into those. I would say the way that it's structured is that the Planning Commission is charged with making findings. The findings include plan consistency. Ultimately, the Planning Commission is the finder of fact when taking final action on the project. However, through the development review process, the completeness determination and the initial consistency determination are handled administratively at the staff level.
That's your assumption.
That's correct.
Okay. All right. So let's see if we can clarify a few points here, because there's some terminology that's used in your memo and used a slightly different terminology here. So I want to make sure that you and I are on the same page as to what we call a specific event. Let's start out with this. Hypothetically, Bob files an application with the city, let's say San Ramon. and Bob wants to develop a piece of property for, let's say, 40 homes.
Mhm.
Let's further assume that this project is subject to the Housing Accountability Act, SB 330, all the bells and whistles. You with me so far?
So far, so good.
Okay. So Bob files the application. And within 30 days after filing the application, Bob gets a long letter from the city staff that says, "Dear Bob, we've reviewed your application and the following 55 things are incomplete. So you need to complete all these things before we deem your application complete." Got me so far?
Yep, that's a pretty standard occurrence in the application process. The
Right.
Bobs of the world are familiar
Right.
with that.
And just out of curiosity,
Mhm.
do you have any information as to the average or median length of time for the city of San Ramon once it receives a housing application to deem it complete?
I do not. That might be something that staff has or might be addressed in the housing element.
Okay, that's fine. So, so Bob diligently goes about putting all this stuff together, and after several hits and misses, he finally gets the prize letter from the city saying, "Dear Bob, we now have deemed your application complete." Okay. Now, under the Housing Accountability Act, as I understand it, the city has an obligation to advise Bob within 30 days in writing whether there are aspects of his project that are inconsistent with the city's general plan, an applicable specific plan, the zoning ordinance, or other city rules. Is that correct?
That's correct.
Does that determination also include a determination whether the design of the project meets city standards?
The determination is to provide written notification of any standards that the project doesn't comply with. Again, the most relevant standards here are whether they're objective standards, because those are the standards that would provide a basis to either deny the project or reduce its density ultimately. But if they're non-objective standards that are not evaluated, but when it comes to the Planning Commission, there's still both the opportunity for the applicant to provide their own analysis as to how they comply or don't comply with those particular standards, or for the Planning Commission to adopt conditions of approval affecting the design of a project, as long as those conditions of approval don't again run into the limits of the HAA by reducing the density, which in the HAA speak is more than just we're adopting a condition that you have fewer units in your project. It's defined as anything that impacts the project's ability to provide housing. So you can work around the margins to address design issues and compatibility issues. Even I would argue using non-objective standards when it's here in front of the commission, as long as the cumulative effect of those conditions and that analysis doesn't result in impacting the project's ability to provide housing.
Well, let me give you an example that you brought this up from, I think the San Mateo case.
Mhm.
Maybe I got the wrong case. Let's assume there is a standard that says if your residential building goes over 3 stories, the 4th and 5th stories have to be set back from the 3rd story by 5 feet.
Yes,
Is that an objective standard?
that sounds objective. And in fact, even in the San Mateo case, the court gave an example very, very close to the same one that you're using. Because the city did have standards that were constructed very similar to that for portions of the project. But then where they tried to rely was on the one where I gave the example of the non-objective standard. But yeah, if you have a standard that is measurable like that, that's very clear. If above the 3rd story, you must step the building back 5 feet, that is going to be constructed and interpreted like an objective standard.
Okay. So let's assume for purposes of Margaret, I'm really gonna leap ahead for a second, that the letter, I'm gonna try and avoid subsections if I can,
Sure.
that goes out to the applicant specifying deficiencies in the application, the project with respect to city standards, doesn't tell him that the setback that he has for his fourth and fifth stories isn't consistent with the city standards. By not telling the applicant that, does the city waive its right to later say, hey, you didn't do a setback of 5 feet, therefore we have to disapprove your project because it doesn't meet our objective design standards?
Yeah, at that point, so if the notice were not provided within 30 days after completeness, then the project would be deemed to satisfy that standard. So the city would not be able to rely on non-compliance with the setback to deny the project or reduce its
Okay,
density.
so the flip side of saying that is that if there are objective design standards that apply to a proposed project, that the city must identify failures in the project to comply with those objective design standards, or the city waives its right to use those deficiencies as grounds for disapproving or changing a project.
I will agree with almost that entire construct. The only thing that gives me a little bit of pause is it's not entirely clear that there's no grounds to change the project. I acknowledge that I just said that it's deemed to comply with that standard. And if something complies with a standard, then arguably you don't have discretion to change it because it already complies. The exact contours of that hasn't been fully vetted and tested in the Court of Appeal yet. If something blatantly contradicts a standard and the city doesn't, clearly we can't deny, we can't reduce the density, but the city maybe adopts a condition that's allows the project still to be approved. Maybe there's still a chance to change the project to affect it. Not entirely clear. That I'm acknowledge that's a little bit of an open question, but everything else about the way you constructed that, I think is exactly right.
That would be sort of what we technically call a squishy condition of approval.
Yeah, exactly. I would have the caution flag up as we were proceeding, and we would have to evaluate the facts and circumstances about whether we thought that was appropriate.
Okay, well, let's go back to Bob now.
Sure.
So Bob now has the letter from the city saying your project's complete. Now, what is the terminology that you use to describe the notice, which can be a letter or whatever, that has to be provided to an applicant of a project subject to the HAA within 30 days, identifying deficiencies of the project with the city's standards?
I think the common vernacular that we'd use is the consistency evaluation. So
I'm sorry?
the consistency evaluation.
Okay.
So the first step, as you pointed out, is the completeness determination. Do we have enough information about the project? Have you provided everything you said we need to assess the project? And then once that's confirmed, then we move on to evaluating consistency or compliance with standards.
Okay, you, in your memo, you use the term compliance determination. Is that the same thing
Same,
as the?
yeah,
Okay,
same thing.
all right. Now, under the HA, which term would you prefer to use? So we're on the same page.
I'll follow your lead.
All right, I'm going to use the term, if I can remember to do it, compliance determination. So first of all, so Bob gets the letter, the city shot clock starts to run.
Mhm.
They have 30 days to provide notice to the applicant if there's a perceived deficiency. Okay, so that's entirely done by staff.
Correct.
Would that be considered a ministerial action?
It's a good question. It is close to ministerial because ideally it will involve no subjective discretion or decision making. It is the rote application of standards to a plan. So it is, yeah, arguably it's a ministerial function.
Okay, all right. So let's assume that staff happily cranks through Bob's completed application. And on day 29, after the completeness date, it decides, lo and behold, that Bob's project is consistent with all city policies, including the general plan, specific plan, whatever. Okay. At that point, the staff drafts the notice and delivers it to Bob saying, congratulations, you have a project that is consistent with our general plan, blah, 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 right? Well, let me put it this way. They can do that.
They
That
can,
is
yeah.
option one.
Exactly. They
Okay.
can do that.
Okay, so let's stick with option one.
Mhm.
And the staff drafts this letter and says, dear applicant, your project is consistent with our general plan. Now, let's talk about the impacts of that letter. That means that the city cannot disapprove or unrestrict on the ways that you talked about, which is reducing density. Would it also include rendering the project economically infeasible?
I would say yes. There's an express prohibition on conditions that would make a project infeasible if the project has 20% affordable. However, I think that it's also reasonable that if you are adopting conditions that are economically infeasible to comply with, you have impacted the project's ability to provide housing. And even if that's not deemed a denial, it would reduce the density, and that would be a violation.
Okay. Now, again, let's assume Bob gets the letter that says your project is consistent with our general plan. As I understand from your memo, basically the city's options from thereafter are, it can only disapprove the project if one, there is a significant risk to the health and safety of the community if the project is built as is, or two, that the project does not have a certified CEQA document. Now, it can be a negative deck, can be a fully IR, whatever,
Mhm.
or could be a letter that says you're exempt from CEQA. Does the city have, other than conditions of approval, which you've, I think, correctly pointed out, work around the edges, have any other ability to disapprove a project other than the two I mentioned, CEQA or significant health and safety?
No, I think at that point, it's akin to the applicant providing their analysis, as long as it's reasoned and enough to convince a reasonable person that they're compliant. It's the same effect, that the project then is protected and the grounds for denial are very narrow, as you
Okay.
articulated.
All right. So would it be fair to say then that if a full compliance letter is sent to an applicant on an HAA project, that basically that is almost tantamount to approving the project?
I wouldn't say that, because of those reservations that we just discussed, that there are still express circumstances where the decision-making body can deny the project. In fact, in that San Mateo, the Carla versus San Mateo case, the city tried to make a similar argument to what you're articulating here, and said that the provisions of the HAA that we're discussing were an improper delegation of municipal authority, either to staff or to the applicant themselves. And the court rejected that line of thinking, explaining that because of the health and safety findings, because of the ability to condition a project and require CEQA compliance, that there was adequate reservation of authority that the city maintained.
Okay. So my next question is, when in this process, again, once the letter has gone out, when does the public find out that a housing project has basically been approved subject to a determination of CEQA or the risk of health and safety that under HAA has to be significant? When does the public find out the project has been blessed?
Yeah, again, I would frame it a little differently. I wouldn't say that it's been approved or been blessed. It's been evaluated for consistency and compliance, and it would be noticed when it's ready for a public hearing Potentially, depending on the level of CEQA review that was being done, a notice of preparation would go out if it was going to be subject to an EIR. If there wasn't going to be an EIR or a negative declaration, if it was just like, if it was CEQA exempt or qualified for other type of streamlining, it would be noticed when it was being processed for hearing.
Okay, so would it be fair to say that under the circumstances we've described for Bob's application, that the first time the public would become aware that this project had received what would be tantamount to approval would be at a noticed public hearing?
Again, I push back a little bit on whether it's tantamount to approval, but yes, I think that the timing that you're getting at is correct.
Okay. The next question would be, again, Bob now has his handy dandy letter. When would be the first time the planning commission would normally learn that staff had found the project to be consistent with the general plan, et cetera?
I would defer in case staff corrects me if I misspeak, but I would say at the same time when the project is being evaluated and presented to the planning commission.
Okay, now let's go back to the impact of the blessing by the city staff. Under these circumstances, does the planning commission have the ability to disapprove a project on grounds of inconsistency once the staff has sent the letter that says the project is consistent?
Most likely not. I would say no, on the grounds of inconsistency with standards, then that would risk violating the HAA.
Okay, now, let's assume, would that also apply to the city council? Were there an appeal from the planning commission's decision on the project?
That's correct. And I'd say the same would be true. Say the planning commission recommends approval of a project and a neighbor doesn't like it, they appeal it to the city council. The fact that the planning commission evaluated it, recommended it, found it consistent would, as long as, again, it meets that reasonable person standard, would have the same effect on the city council and limiting their discretion to overrule the determination that the planning commission has
Okay.
made.
So is it fair to say that if the planning staff issues the letter that we've been talking about to Bob without a public hearing having been held on that, that both the planning commission and the city council are bound by the determination that staff has made of consistency?
That, yes, that an evaluation of consistency is enough to deem a project compliant.
Okay, so let's take a slightly different hypothetical.
Mhm.
Let's assume that at the end of 30 days, for whatever reason, staff hasn't drafted the letter to Bob.
Mhm.
And on day 31, after the completeness declaration, Bob wakes up and said, I never got the letter within 30 days. Is the impact of the failure to provide notice to Bob tantamount to having a letter to Bob saying, you got it, you're complete, you're satisfying all our standards?
Yeah, I would say in general, yes, that if the timely notice is not provided, then the project is deemed to comply with standards. The one potential difference is that if there's not that second level of analysis that says you affirmatively, we agree that this is consistent for X, Y, and Z reason, then the second path for something being deemed complete hasn't been triggered yet. Because there's two ways for projects to be deemed complete. One is the failure to provide notice. The other is therefore to be substantial evidence sufficient for a reasonable person, regardless of where that evidence came from. So in their first hypothetical, arguably there's two paths for the project to be deemed consistent. In the second hypothetical, it's just the one. I mean, the effect at the end of the day is probably the same, that because you only need one way to get to the answer, but for the sake of completeness, I guess I thought that all through to differentiate them a little bit. But failure to send a timely notice has the effect of deeming the project consistent with standards and limiting the ability to deny that project to the bases we've already talked about.
Oh, okay, let's try a third hypothetical.
Mhm.
Instead of Bob getting a letter from the staff saying, congratulations, we have deemed your project consistent with our general plan, they get a letter that base says, Bob, you know, there's these three things about your project that we don't think fit the objective standards of our general plan or zoning ordinance, as the case may be.
Mhm.
The first question is, when Bob gets that letter, is that a per se disapproval of the project?
Definitely not.
Okay. Second, after Bob receives this letter, does he have the ability to go back to either the planning staff or go to the planning commission and say, hey, guys, you know, I got your letter. I saw what you said. Let me explain to you why you're wrong on this point, that I have met objective standards. If Bob goes back, let's just say to the planning commission, to hearing number one, and says, hey, guys, I really am consistent. And the planning commission looks at it and says, you know, Bob, I think you're right. Can the planning staff basically overrule the planning staff and say, we think this project in fact is consistent on these 3 points, and we're going to make a finding that it is?
Yeah, when the project is before the planning commission, and that's always the planning commission's prerogative. I'd also say that, I mean, even if the planning commission didn't agree with the applicant's determination, say planning commission was inclined to agree with staff and say, we don't think that you're compliant with this setback requirement, but the applicant has a good explanation as to why it is, because of the way that they measure the setback is consistent with the city's standard practice of measuring setbacks, and staff has come up with a new calculation that it doesn't like, it's not reasonable, and whatever hypothetical you want to go down. Even if staff and planning commission are aligned, if applicant's argument is reasonable and they have evidence to support it, then ultimately a court should, under the language of the HAA, side with the applicant, because that's that second path to being deemed consistent with a standard, that if the applicant or anyone else is able to provide evidence that's enough to convince a reasonable person that they're consistent, they're deemed consistent by a matter of law, same as what we were talking about before.
Okay, so would it be fair to say that even though the planning staff issued a efficiency letter
Mhm.
on the compliance determination to the applicant still has the ability to go to the planning commission at hearing 1 or 2 or 3 or 4 and convince the planning commission that the project is in fact consistent with the general plan, and the planning commission has the ability at hearing 1 or 2 or 3 or 4 to say, you're right, we find this project consistent.
Yes.
Okay.
And the only other interpretive gloss, to borrow one of the court's phrases, that I would add to that is that if there was enough room to disagree about the standard, where staff could come to one conclusion, the applicant could come to another conclusion, planning commission is maybe somewhere in the middle and has to be the tiebreaker, then that standard probably isn't specific enough to be objective anyway, and wouldn't have provided a basis to deny or reduce the density of the project under the HAA. If there really is enough room to disagree about the interpretation, then it probably wouldn't meet that definition of objective.
And what you're just talking about is if the applicant got denied the project by the planning commission and or on appeal to city council and filed a writ of mandate application with the Superior Court to have the city's determination overturned. That's what you're talking about.
That's correct.
But just so we're clear, the planning commission retains the authority right up to the time that it issues a resolution, either approving or disapproving the project, to find that the project in fact is consistent and to make that ruling at that time.
Yep, that's correct. And I would say that I don't think any of the hypotheticals or rules really change that function, that at the end of the day, it's the planning commissioner is charged, the planning commission as a body is charged with making those findings, acting as the finder of fact for the city on these types of applications. The way it does that is somewhat constrained based on all the rules we've been talking about, but the role itself and the resolution taking action, that responsibility continues to lie with the planning commission.
Okay, so to sum up with poor Bob,
Yeah, he's been through a lot so far.
yes, he has. If he gets the letter from the planning staff that says your project is approved, that's binding, and I'm sorry, wrong word. A letter that says your project is consistent with city standards, then that letter from staff is binding on the planning commission and the city council on those standards. 1, 2, if staff doesn't send the letter, then as a matter of law, the project is deemed consistent with city standards. And that also is binding on the planning commission and the city council. But 3, if staff sends a letter that says you're deficient on these aspects of your plan, the planning commission, and if necessary, the city council has the authority to an opportunity to overrule the planning staff's opinion and deem the project consistent with the city standards. Is that right?
That's correct. So yeah, under that last hypothetical, just to make sure that I followed all the way through. There's a letter identifying inconsistencies with city standards, then those standards would remain a basis for the planning commission or ultimately the city council to deny that project or reduce its density if they find that the project does in fact not comply with those standards.
Okay. Thank you. That's all the questions, the other Eric I have.
Great. Well,
Madam Chair, can I just ask a clarification question on the last couple of points?
Absolutely.
Using small words and short sentences. Could you please answer this question? The staff determines general plan consistency and so states in a letter that goes to the applicant. The planning commission does not agree. Are you saying that the planning commission can find when we adopt a resolution or we fail to adopt a resolution? Does the planning commission have the freedom to say this project is inconsistent with the general plan? Now you're at the back end of the process, from 30 days out to whatever time it takes to get to the 5th or the 4th hearing.
yeah, so that's a good question. I think it's helpful to drill down a little bit to what a consistency evaluation or that second letter would look like. I don't think it's standard practice for jurisdictions to make a high level determination that you are consistent with the specific plan, or this project is on all fours. It meets all the criteria of our specific plan. Usually what those do is they'll go through specific policies and evaluate whether those policies have been met or where those policies and standards have fallen short, so that the applicant has the opportunity to amend their application, correct the project, and have something that is ready to be presented to the planning commission and ultimately the city council. But to your specific question, again, if staff has determined that a project, say it's consistent with the density standard in the general plan, or it didn't act and no notice was given under either of those circumstances, that should be enough to deem that project consistent with the general plan's density standard. So then when it comes to the planning commission, if it's following the Housing Accountability Act, should treat the project as consistent with that density standard. That doesn't mean that you have to ultimately find that the project is consistent with the overarching general plan, but it does mean that you can't deny the project or reduce its density based on its compliance with the density standard in the general plan. So I don't know if that helps or made it more confusing.
Small words, short sentences.
Short
we
sentences are not
we
my
get to the
strength, I
point.
apologize.
I know attorneys have a problem with that. The staff sends a letter out saying that your project is consistent with the general plan for the following reasons.
Mhm.
And several weeks later, months later, the planning commission determines that what the staff said in one or more of the reasons for saying there was consistency, and it doesn't reduce density. I know you can't reduce density here, but this planning commission does not agree with what the letter said. Are we on legal grounds to deny the project?
Well, I would say that if it's a position where the planning commission can disagree,
Mhm.
you're not on legal grounds to deny the project anyway, based on the way that the HAA is constructed, because the HAA only lets you deny the project based on objective standards.
Right.
So if it's possible to disagree, then the standard probably isn't objective and wouldn't provide a legal basis to deny the project anyway. So I think that there probably would not be a legal path to denying the project there, though where there might be opportunity to influence the project again is through the conditions of approval, as long as they don't reduce the density of the project. And that can bring it into compliance with the commission's view of what's necessary to advance the goals of the general plan.
Are there other questions?
I do have
Okay,
some.
Commissioner Mark.
In that case, I was just trying to understand a little better what was said. This is a general question that reflects my sense of what is happening to planning commissions and review of projects. Given the totality of what the Housing Crisis Act, the Housing Accountability Act, SB 8, SB 9 have done to the planning process, other than what you have under Planning Commission reserved authority, really what's left for a planning commission to do?
No, that's a great question. I acknowledge one that planning departments and planning commissions throughout California are asking and kind of grappling with. Where I keep coming back to is the idea of the advanced planning and coming up with objective standards that can be applied consistently and routinely, and having those in place in advance of a project being approved. What the suite of laws that you mentioned and other ones like the density bonus law, they really do limit the planning commission's ability to be an ad hoc project by project decision-making body. That it's very much limited by design under the state housing laws. But what the planning commission is empowered to do still is advise the city council as to what the right development standards are and what the right objective standards are to be incorporated into general plan, specific plan, zoning code, et cetera, so that development that comes forward follows the standards and the guidance that the planning commissions and ultimately councils have adopted.
Having said that, and I have reluctantly come to that same conclusion, what it really augurs for in the current planning process is recognizing that traditional design review is dead, and objective standards need to be developed if you don't have them. We are a city that has pretty typical objective standards relative to FAR, height, placement, setbacks, landscaping, etc. But it seems to me that our job going forward, and I'd like to see if you agree, is to take a broader look at what we used to do in the design review process, and come up with objective standards that will accomplish the same thing or very much the same thing, and then rely on those. And to that end, if I may, I'd like to read 4 not proposed, but sample objectives and see if you think that they meet the test.
Sounds good.
And I'm looking at what I call quality of life standards, or design-oriented standards. And the first one reads as follows: regarding private open space for townhouses, either standalone projects or in a mixed-use development. All townhouse residential developments and all townhouse residential developments proposed in mixed-use developments shall include at least one privately owned and operated park or open space that is enclosed by a 6-foot tall wrought iron fence and gate, includes a cement walking path around the perimeter, includes at least 4 powder-coated metal park benches, and a play structure or equipment designed for use by children between the ages of 2 and 5 years old. I've tried to be very specific. Do you think that meets the test?
I have a couple of questions for it. One, how much open space is required per unit?
How many? I don't
So
have
that-
that standard.
Yeah,
I
so
don't-
that would, that would need to be maybe it's not in that specific standard, but that would need to be defined somewhere so that there's a hook to know how
Okay.
much is being provided. And then the characteristics that you gave in terms of like specific elements that need to be included, I do think are objective because they're measurable. You had specific heights, specific materials, specific numbers. Those are all things that are knowable in advance. You can check them against a specific standard and say, does it meet this standard? So I do think that construct would be
Okay.
objective. The only one that maybe even gave me a little bit of pause was the age range, the equipment designed for kids of a particular age. Maybe there's some room to debate whether swing set is good for 2-year-olds or not, but those often come with age ranges. Like I have a small child and go to tot lots and the equipment is stamped with this tot lot is designed for kids of a certain age, that this is the 2 to 5-year-old area. This is the 7 to 14-year-old area. So there are ratings out there that can be used to guide that.
Right.
So that probably is sufficient, but I'd want to think about that a little harder before saying 100%.
Here's another one regarding perimeter landscape density. Perimeter landscaping shall consist of an offset double row of evergreen trees planted with 15-foot centers and planted behind a minimum 3-foot wide row of drought-tolerant shrubs and ground covers.
Yeah.
And again, I'm just trying to get a sense of
Yeah.
how do you write these kinds
I
of
think
things?
that's pretty close. The other thing that would help that standard is if there was a landscape palette that showed plantings that were approved drought tolerant plantings, that could help give additional specificity. But yeah, that in general sounds right to me too.
One more. This is a development's streetscape. In order to create an interesting streetscape, each townhouse front yard shall be planted with at least one evergreen tree.
Yeah, and then as long as there wasn't a debate about how big the tree had to be, how mature it was, where in the yard it went, like there's lots of different ways to
There's
satisfy that
flexibility in
standard.
there.
But yeah, that would be permissible.
Okay, one last one. And this is about garage driveways. All driveways directly serving townhouse units shall be a minimum of 20 feet in length as measured from the public or private street immediately accessing the unit to the vehicle entry door of the garage.
Yeah, that sounds
Okay.
objective to me.
So I think I get the drift of what
Mhm.
these are supposed to be. Again, in my experience, cities don't have a lot of this stuff. They certainly have the typical FAR placement, height, setback, etc. But through the design review process, that's how on a site specific and plan specific basis, even though we may use, what do they call it? Something or other gloss, we have to avoid that. But we have to take a look at our objectives that we used to use that process for and expand into areas that we traditionally did not have objective standards for. And you think there's enough latitude in the law to allow us to do that if the objective is as specific as it needs to be.
Yes, yeah, in fact, that's ultimately what we recommend to address these types of issues is that develop adequate objective standards to express what it means to be an interesting streetscape or accessible open spaces that serve the varied needs of our communities. Like those are all the types of terms that planning codes used to have and probably still do have, but no one knows how to apply that. But the types of standards you were doing would be an objective way to comply with that. And then it's much easier for applicants, for the public, for staff, and ultimately the decision makers to know whether or not an application is doing the things that the city says that it wants.
Okay, thank you.
Commissioner Edwards, I do have a quick question. So it is, I'm going to use the hypothetical here.
Sure.
And I'm referring to your slide, which is what is an objective standard here, where it says that the criterion should be available and knowable. So let us say that hypothetically, as humans often do, we get in a habit of following like, well, this is how we've always done it. And as a shorthand, we think we know what the rules are, but because we've always done it, we're pretty sure we're following the rules, but we didn't really actually go check.
Mm-hmm.
Okay. So Bob comes along and says, well, I've heard that San Ramon has always done it this way, but yet someone else comes along and says, but I actually looked this up and they haven't really been following what they have in their rules. I'm sure it does not happen into perfect San Ramon, but it might happen in a neighboring town. So how does this fall in the realm of knowable, available, and knowable consistency versus if I go to the books and the books say, this is our ruling?
Yeah.
Who wins?
That's a good question. I think it comes down to how clear is that rule on the books? Does it really fit within this objective standard definition? If there's room for interpretation about how the standard is supposed to apply, well, then it probably isn't objective. And we'd be looking then to see, is the city's interpretation of it reasonable? If the city is supporting approval of the project, if the city is using that interpretation to deny the project, then the question becomes, are there other interpretations that have been advanced that are reasonable, that support approval? And then that's the one that carries the day. But if backing up to where you started the question, if it is truly an objective standard and it's written and there's no room for interpreting how to apply it, that's the standard on the page is the one that's supposed to carry the day.
I have one more quick question. Pardon me. And again, this is a slide prior to that, where it says we can only reduce density if there's a specific impact to public health and safety. It strikes me, and maybe this is more of a comment than a question. It strikes me as that reason to deny something is as quintessentially subjective as conceivably possible. There's absolutely nothing in that statement that has any kind of quantitative, identifiable, measurable standard.
You're correct in that the summary that I put on the slide the standard is the specific adverse impact to public health and safety, but that term itself is defined in the Housing Accountability
Okay.
Act, and the definition of a specific adverse impact to public health and safety is one that's based on, it has to be a written public health standard that was in place at the time the project was found to be complete, and it has to be objective. So a general finding that the traffic volumes are going to be hazardous to pedestrians in this area, even though that might be true, it's not enough to trigger the HAA definition of a specific adverse impact. The city would have to have an analytical standard about crash data or visibility corners or something like that, that was meant to protect pedestrians crossing the street, and then show that that were being violated in order for this to be triggered.
Thank you.
All right, any other questions? All right, Madam Recording Secretary, do we have late communications, speaker cards, or speakers in the Zoom audience?
I have a speaker card here for Gary Chabon, and I do have raised hands in the audience.
How many?
Just one at this time.
All right, as we move into the public comment, I wanted to just remind our speakers about the attendee conduct guidelines that appear in the meeting procedure section of the Planning Commission agenda. And just to also remind folks that item 2.1 is a policy discussion. It does not pertain to any particular project. With that, we can open the public comment.
Good evening,
Good evening.
Madam Vice Chair, Commissioners, staff. My name is Gary Chabon. I'm a 45-year resident of San Ramon. Seen a few changes. As I listen tonight, I think I'm going to see a few more. If I might ask Mr. Phillips a question? Is that?
He may ask a question of the commission, and if the commission so
Okay.
wants to get an answer, then he can do it that way.
All right,
So-
thank you.
Commission. If there's an approval 5 years, 4 years, 3 years ago, and they haven't broken ground, does that mean that none of the new standards apply? Does that make sense?
Question makes sense.
Yeah, the question makes sense.
Okay.
The question makes sense. I'm not in a position to answer it.
Okay.
I don't know if this was intended for me or for Eric, but if there was an approval, it depends on the lifespan of the approval. If, for example, there's a tentative map, and if that map has not expired, then the developer has the right to develop pursuant to that map.
All right, so we have limited time, so I'm sorry. I'd
It's
like to
okay.
just ask you
I
to
just-
continue.
I was just curious, it just seems like there are some very important things that could happen in a 5-year period that would affect the residents of San Ramon in a construction project. And I'm just want to make sure that we're all being protected. So I'm noticing that not just mornings and afternoons, the congestion is getting really tight in San Ramon. Things are happening. And so these projects that we're talking about are going to affect that. And so the ingress egress is becoming a problem for most of my neighbors.
Okay, let me ask you to limit your comments to the agenda item that you're speaking on, number
Okay.
12.1, the
Well, it
policy.
seems to me that any construction that takes place is a huge impact upon ingress and egress. That's why that's fine. I noticed that there is an opportunity for economic development to be part of the projects that we're talking about here, which would be the multi-use, right? Would that be correct? Okay. How does that affect our economic development? That's my concern, is we're taking housing, put it in. How do we get more economic development to bring tax base in? So those are my questions as I speak to the commission.
Thank you.
Thank you for your time.
Jim Blickenstaff.
Good evening.
Good evening. I assume you can. Can you hear me?
We can.
Oh, good. Okay. Yeah, I just want to very quickly quote something that is relevant here, and maybe more explicit than was mentioned earlier. It has to do with a San Mateo ruling and that decision in September of 2021. I'll just quote very briefly. Even with respect to standards that are not objective, the HAA does not bar local agencies from imposing conditions of approval. Rather, it prohibits conditions of approval that the project be developed at a lower density unless public health and safety findings are made. And local governments are not barred from imposing conditions of approval that do not reduce density. That's a black and white statement of part of the decision in the 2021 ruling at the San Mateo level. And beyond that, I wanted to also mention that the decision coming before not just the Planning Commission, but the City Council is, do you basically want to defer your authority to look at and rule on developments that affect the city and its future planning to staff, as SB 330 implies. And we've seen repercussions of that already, because guess what? When staff decides about objective standards, they're using their own opinions, their own biases, their own subjectivity to decide what constitutes that standard and what other standards they'll ignore. And they put out a list of 10 and they send it to the developer, and fait accompli, now you're in a straitjacket to do much about it. At least that's the implication. But like I noted a little earlier, there is a judgment on SB 330. It does allow discretion, if you want to call it that, within the Planning Commission in terms of conditions of approval. I hope you explore that to the full extent possible. But the bottom line is, excuse me? So very quickly to wrap up, the bottom line is that I'd rather see the Planning Commission and the City Council make decisions of what constitute objective standards with all their connections with their constituents, and they're being elected bodies and then appointed, rather than staff. I think the purview of that is more thorough, and I trust your discretion more than staff's discretion to make a list of objective standards, and then it's carved and granted from that point on. So let's just be sure we maintain our legislative rights here for the Planning Commission and City Council to still have the decision-making authority. And that implies to me that they should be the deciders of objective standards with the best legal advice they can get, and take it or leave it. We'll do the decision. That seems to simplify the dilemma that's going on here by deferring those to staff. Thank you.
Thank you.
No other hands raised.
Then we will close the public comment. Do the commissioners have comments, discussion?
Yes.
Commissioner Wallace, would you like to start us off?
I guess it's fair and reasonable that I start off our discussion, since I'm the one that was primarily responsible for us spending Tuesday night here on this. And so I wrote down a number of thoughts. I'm going to try and make them as succinct as I can, but sometimes I get carried away. In mid-October of last year, after learning that the planning staff had issued a notice to the applicant for the marketplace that the project was consistent with city standards, including the general plan and zoning ordinance, contrary to instructions staff was given at the October 4, 222 meeting. Several planning commissioners initiated a series of meetings and conversations with the planning staff and city attorney, during which the commissioners repeatedly reiterated their view that under the city's current operating rules, including the zoning ordinance, that the decision required by the Housing Accountability Act that we've been referring to as the compliance determination or initial consistency evaluation was to be made by the Planning Commission, not staff. This included the memo that you have in the package from the staff that I wrote to the city attorney back in late October of last year, outlining why at the present time the city rules required that the Planning Commission make the decision on consistency with the general plan, even for HAA projects. The whole point to this meeting tonight was to flesh out that issue, not what the city rules should be, but what they actually are now, because you have to start from someplace, and the someplace is who makes the decision now. As I pointed out with the speaker, the memo that was prepared by outside counsel for the city never addressed that issue at all. Rather, it assumed that the practice of the city of San Ramon was to have planning staff issue the initial valuation, the initial consistency determination, not the Planning Commission. That, as I put in my memo to Mr. License last year, is inaccurate. That is not the way our city code reads. Now, what the memo that was prepared by the Burke law firm, and I mean no respect, but I usually refer to law firms by the first name, Burke, as opposed to Burke Williams. Like I never referred to Crosby, Heafy, Roach and May as Crosby, Heafy, Roach and May, but the Crosby firm, and everybody knew what I was talking about. The essence of that memo is that what the city should do is to allow the planning staff to determine whether a project is consistent with our general plan within that 30-day period. But that, as I've shown, and I have not been disputed, is inconsistent with our zoning ordinance. And what is even actually more frightening for me is the analysis in the Burke memo towards the end that our speaker tonight, Mr. Phillips, was able to enunciate fairly clearly, was what placing this decision in the hands of city staff would do. To start with, I'll go into a little more detail, but here's the really, really frightening part. According to the Burke memo and Mr. Phillips' testimony tonight, the upshot of allowing staff to make this initial determination, whether you call it an administrative decision or a ministerial position, is that in essence, the decision whether to approve a housing project in the city of San Ramon not only will be made by staff, but it will be made in secret. No one will know that this decision has been made until it pops up at a planning commission meeting. No one will have the opportunity to participate in this decision process, including whether the project is consistent with our general plan. I cannot think of a better way to have the citizens come out with their torches and pitchforks than to adopt that policy. The way this whole process came up was over a year ago, in Windflower Fields. when we had a hearing in this chamber about whether the Windflower townhomes were consistent with our San Ramon Village, what is now our San Ramon Village Plan. It was then Crow Canyon specific plan. Inclusionary housing requirements for providing affordable housing units. The applicant proposed to use ADUs, which didn't have to be rented, as the affordable housing component. This commission felt and said that that was not allowable under our specific plan, but we were told by the applicant's attorney, and that was confirmed by staff, that because we, the city, had not provided the applicant with written notice that that part of the project was deficient under our specific plan, that we had waived the ability to raise that as a reason for disapproving the project. At that point, the planning commission asked city staff to make sure that in future HAA situations, the planning commission was given sufficient notice of the completeness of an application to schedule a hearing to weigh in and decide whether the project was consistent with our city standards. And city staff agreed to do that. Then we came to the Marketplace project. We had a hearing on October 4th, 2022, almost to the day after the hearing on Windflower Fields was held, where we discussed whether the proposed project was consistent with our general and plan and zoning ordinance in two very specific areas: the density calculation and whether it was truly a mixed use project. The planning commission was of the opinion that a letter should be sent to the applicant explaining we found these deficiencies in order to preserve the city's rights to have further conversations with the applicant to flesh this out. Because if the letter wasn't sent, then we'd waive our right to raise those issues later on. Planning staff heard our discussion and, as far as we knew, had agreed to provide the letter. The deadline for the letter was October 17th. No one from the planning commission was told ahead of time or received a draft of the letter that went out to the applicant that stated the exact opposite of what the planning commission said. It said, option number 2 on the hypothetical that I gave Mr. Phillips, that in fact, the plan was consistent with all city policies. The letter was sent to the applicant on the 17th, but no one from the planning commission received a copy of it. It was not until the next day, shortly before the October 18 meeting, that the commission received a copy of the letter, and only then, because I had asked staff that morning to send a copy of the letter because I was curious about what language they used, by having given Mr. Barr a memo shortly after the meeting that went through my analysis as to why those two particular points were valid objections to the project. It turned out that the 18th, that the staff had sent a letter directly opposite of what we wanted. And that's when this entire subject came up. And over the next couple of weeks, myself, our chair, and Commissioner Marks went to the staff and explained our concerns for them. I had individual conversations with our city attorney, and I provided the city attorney with a memo outlining why I felt that under the current city rules, the planning commission, not the staff, made the determination under the Housing Accountability Act at that 30-day point, whether there was consistency with the general plan. And the point was to have a meeting that was designed to discuss this point and to reach a decision as between the planning commission and planning staff, whether they were in agreement as to who had the authority to write that letter. And that's why we are here. Now, the memo that Mr. Phillips' firm raised does not cover that. What it does cover in 4 or 5 sections is, first of all, a history of the language of the Housing Accountability Act, which I don't dispute, but it's really irrelevant to the conversation we're having, which has to do specifically with the city of San Ramon's provisions for making this determination. Section 2 of the memo states that the compliance determination must be based on a quote objective standards, close quote. Again, there is no dispute that that's the standard by which the city makes that determination. I will point out that Mr. Phillips offered that in addition to compliance with a general plan or specific plan or zoning ordinance, that compliance determination also includes objective design standards. And the reason I brought that up with Mr. Phillips, and I will mention later on, will become apparent when we get to that part of my discussion. Mr. Phillips, the Burke memo also discusses in section 3 what happens when a letter is delivered or not delivered to the applicant on that 30-day compliance determination period. And digress for a second, there's 3 possibilities. One is that the staff doesn't write a letter, and that's what happened at Windflower Fields. The upshot, as Mr. Phillips agreed, and I agree with him, is that the city, and when I say the city, I mean the Planning Commission and our friends upstairs at the City Council, are precluded from denying a project based on anything that would be considered an inconsistency with our standards, such as the general plan and zoning ordinance. The second option was that the city writes a letter that says you're copacetic with our general plan, zoning ordinance, and everything else we can think of. That's what occurred at the marketplace. And as our city attorney, not Mr. License, but our friend Ms. Poon, sitting in the audience, who told us, as Mr. Phillips also echoed, that the impact of that letter was to preclude the city from rejecting the project on any grounds that had to do with inconsistency with our general plan. Now, one of the things that the Burke memo points out, or at least argues is a better terminology for it, in section 4 of the memo is what I would consider, as a litigator, parade of horribles. If you allow the Planning Commission to make this initial determination, here's all the terrible things that can happen. One of the things they talked about was that the compressed time frame for an application being deemed complete and the time the city has to make that determination. But you'll recall, hopefully, that when we were discussing the Marketplace project last Thursday, I asked Mr. Driscoll, and I confirmed by going back to their original paperwork, that the original application for Marketplace was filed with the city in February. And that initial filing included the description of the density based on the 40 townhomes, and also on the fact that the project did not intend to provide new non-residential buildings on the subject premises, excuse me. Those are the 2 points that we pointed to on October 4th as why the project was not consistent with our general plan and zoning ordinance. That means that staff and the Planning Commission had 7 months to go over and flesh out these issues before the completeness was done. And even though the Planning Commission had asked in the past to be notified of projects that had been filed but were not deemed complete, that raised HAA problems. So we could look at that paperwork ahead of time. We didn't get any invitation to do that. Notwithstanding that, when the time came to talk about the compliance, staff was able to set a hearing midway through the 30-day period on October 4. That's 2 weeks before the deadline, and was able to draft a letter and deliver it to the applicant within that 30-day period. Now, I believe that if you look at the history of housing applications in San Ramon, you will find that in the most parts, the elapse of time between filing an application and getting a completeness determination is months. That is more than enough time for the planning staff, even if it doesn't talk to us ahead of time, to figure out whether the plan is compliant or not, and to have a hearing with us to discuss that. I do not believe this condensed time frame that the Burke memo relies upon is really a significant detriment to the Planning Commission making that determination. Now, the Burke memo also contains the representation or worry that if the Planning Commission makes that initial determination, it quote, might set incorrect expectations that the city has authority to enforce changes against a project that are not based in law, close quote. Well, the first thing I want to point out is in my colloquy with Mr. Phillips, he forthrightly said that sending a notice to the applicant advising that the Planning Commission saw deficiencies in the project vis-a-vis our general plan and other city standards was not a per se denial of the project. What it did was to open up a dialogue between the Planning Commission and the applicant over the issues that the Planning Commission saw as a problem with the project. Now, the applicant had a variety of options to use during that period of time, as Mr. Phillips pointed out. First, it could change the project to meet the Planning Commission's concerns. Second of all, the applicant could meet with the Planning Commission, such as at a public hearing, and explain to the Commission why the Commission's concerns were invalid and that the project, in fact, was copacetic with the general plan. The third was that the applicant could take the position that my plan is consistent, I ain't going to change it, so Fisher cut bait on approval. What the letter would do would allow us to have that conversation, but if once staff set out the letter that said, hey, it's cool, we lost that ability to deal with those particular issues. And in the future, if we allow staff to write that compliance determination letter, we run the risk that we will lose the right to question a project, either because a letter wasn't sent or because staff believe the project was consistent with the general plan, despite what the Planning Commission said. That is why the Planning Commission has to exercise its authority under our rules to issue that letter, hopefully written by staff, but if it has to, damn it, the chair of the Planning Commission can sign the letter. And this is where I want to bring up the part that I really find frightening about how the idea that staff would make the initial determination. And it has nothing to do whether staff has the ability to make an objective determination on consistency with the general plan. I am not worried about them making totally subjective opinions about those process. I do believe, as I've said, that I think that their interpretation of our standards is incorrect in some areas. But what it really, really concerns me is the fact that, as outlined by Mr. Phillips, the planning staff's decision-making is done in secret. It is not done in a public hearing. It is not open to public discussion. It is done, and forgive me for using this political terminology, but it's done in the back room. And the city, not only its citizens, but the Planning Commission and the City Council will only learn that there has been a de facto approval of this project when it pops up at a public hearing, when it's too late to do anything about it. And that's the part I really object to. Our city relies and prides itself on having a transparent planning process. To allow staff to do this in secret without participation by public or a planning commission is totally antithetical to everything this city stands for. And while I have great confidence in staff, to allow this to proceed under that basis, to me, is reckless. It is going to engender such a backlash in this city, when that first project gets approved like that, that will make the hearings we had on Church of the Valley look like a cakewalk. Now, Mr. Phillips did point out in section 5 of the memo that even if staff writes the letter or doesn't write the letter and the project is deemed consistent with our general plan, our planning commission still has the opportunity to do something. What does it have the ability to do? Well, first, it has the ability to deny a project on the grounds that it poses a significant health and safety risk to our city. And leaving aside the problems in trying to reach that decision that Mr. Phillips pointed out, which is it has to be A, in writing, and B, using an objective standard of danger. I've been on the Planning Commission for 13 years. We have never denied a project based on the risk of health to the city. The second way to deny a project is based on a CEQA problem. Most of the projects we're going to see, and we have seen, are basically infill projects for which there is a categorical exemption from CEQA. But let's leave aside that. Let's assume that someone actually has to make a CEQA determination. It doesn't have to be a full EIR. It could be a negative declaration or some version of common sense. In the 13 years that I've been on the Planning Commission, I don't recall a situation where a housing project was ever denied on the basis of a CEQA valuation. Never. So the two main ways our Planning Commission under this scenario can exercise any influence on a housing project that's subject to the HAA is not only hypothetical and totally speculative, it's never going to happen. It's unrealistic. It's a figment of people's imagination. So that leaves conditions of approval. Well, the fact is, all of you have sat through those hearings, and you know that 90% of the conditions of approval we approve are standard conditions off the shelf that staff has worked out in years past. The few conditions of approval that we exercise some influence over are things like making sure that reclaimed water is used in construction, that what hours are used to do construction, things of that sort, not make or break deals. And as Mr. Phillips pointed out correctly, the use of conditions of approval to basically sub silencio deny a project because of the impact it has on either the economics of the project or that it would cause a diminution in the density of the project below what the applicant has applied for, can't be done. As he correctly pointed out, all the conditions of approval that are left to the Planning Commission, once an initial determination has been made by staff, is to basically nibble around the edges. And that's not what this Planning Commission is here for. That does not make any efficient use of our time. Now, Mr. Phillips attached to his memo a chart of what he claimed were how other cities acted in connection with this determination. Now, there is no documentary evidence about that. I don't know what other cities' rules are, and I particularly haven't been given anything that shows that the rules in, say, Orinda about who makes this decision, which is the issue here, are so similar to San Ramon that what they do in Orinda has any relevance whatsoever. The other thing was that it's not clear to me, although I take it from comments that Mr. Phillips made, that the initial consistency determination is what his memo describes as the compliance determination, which is basically the decision of consistency with a city's general plan that ties the hands of the Planning Commission and the City Council in terms of consistency. Now, I did something a little different. I went to a group that's affiliated with the League of California Cities, and they're currently working on objective design standards, which, as Mr. Phillips correctly pointed out, is basically something that must be considered in the initial compliance determination process. And a chart was put together by the principal planner for the city of Folsom to list what comments have come in from other cities. Now, I don't pretend that the chart that she created, that I borrowed, represents all what's happening in the state of California. But there are two cities that responded that I want to direct your attention to, and I apologize for the type being so small, but to try and get everything on an Excel spreadsheet in one page was a little difficult. And the first one has to do with what the city of Folsom said. The comments by the city of Folsom's principal planner said this, quote, "We are in the middle of the process of preparing objective design standards and creating a new design process in our zoning code. What our consultant, Mintner Harnish, told us was that there is a wide range of opinions about whether objective design standards require ministerial review. There appears to be different opinions from different city attorneys and among consultants and planners." Now, apart from the fact that there is allegedly a difference of opinion on ministerial review, I will point out that the consultant for the city of Folsom is the same consultant that the city of San Ramon uses. The second response that I want to point to your attention happens to come from one of our Tri-Valley neighbors, which is the city of Pleasanton. Now, I realize that Pleasanton is in Alameda County as opposed to Contra Costa, but I think being in the Tri-Valley, its attitudes are probably more relevant to us than, say, another city in Contra Costa that really doesn't share our environment, say Antioch. And what Pleasanton said in response to the survey request was this, quote, "Design review will still be handled by Planning Commission so that public is aware of projects, even though projects are subject to objective design standards." Now that sort of crystallizes what the issue here in a way is. The issue is whether our current city rules require the Planning Commission to make this determination. If you agree with me that that's correct, and I have seen no analysis, even after 3 months of asking for it, that I'm wrong, then the default position is we make the initial consistency determination, AKA compliance determination. If staff wants to change that to be in line with what it believes apparently is the predominant view among California cities, then it is up to staff to go to the city council and ask them to change our city rules to allow that, at which time we will have a robust discussion with the city council about the impact of allowing that decision to be made that way. If, on the other hand, staff maintains its view that this decision must be made by planning staff along the lines that Mr. Phillips discussed, then I would ask the Planning Commission to take steps to go up the food chain and get a determination about whether the staff's view is correct or not. That could go to the current city manager who was a planning commissioner in another city, or if necessary, it could go to the city council, because after all, that's where the buck stops. So in terms of what we need going further, the first thing we need is to have an answer from staff, whether in future projects subject to the HAA, that staff intends to make its own determination about whether a project is consistent with our city rules, and to deliver such a notice to the applicant, regardless of what the Planning Commission's views are. It's only when we get that answer that we can decide what needs to be done. I realize I've taken up a few minutes here, but I appreciate your patience in listening to me. I have put a fair amount of time into dealing with this issue. I think because of the consequences that were laid out in Mr. Phillips' presentation, that it is maybe one of the more important decisions that you and I will make in terms of how residential projects in San Ramon going forward are dealt with. And I thank you for your time.
Other comments, thoughts, feelings to share? Commissioner Kuznick.
Thank you. I'm inclined to see the value in Commissioner Wallace's point that, and I have referenced this frequently in my comments on other topics, is that a large part of what we do as commissioners in representing the citizens of San Ramon is both educational as well as, decisive. It is a brave new world in which that we're tasked with this problem. But I would think that his point being that this is a city function and our function is to represent the citizens of the city, that it is very important that we do retain some level of decision-making in this. I am not comfortable with the idea that a project comes to us with our hands tied. And so in that regard, I am in favor of this, of us finding a way that we get to weigh in that 30-day window as we look at the same sort of rules, the same sort of objective standards, and perhaps read them a little differently. And we allow the public to see a robust discussion of them if there's a difference of opinion. That is what we are tasked to do. And I do believe that we are capable of meeting that obligation to the law in that 30-day window and meet our obligation as members of the Planning Commission to both the City Council, who have selected us for this role, and to the citizens that count on us to be their voice in these matters. So that is, and I do believe that the staff works and does an excellent job, but I also agree that this is really important to be public and transparent and open to citizens being able to weigh in on it. Thank you.
Commissioner Marks.
Madam Chair. First, I want to thank Eric for the time and effort that he put into reviewing this. I agree with him on almost every point. And again, it is not really an intended slam at staff, but I believe that the decision of general plan consistency is a basic one that belongs to the Planning Commission. And by gutting it, I'm finding that the remaining purposes of having a general plan become unclear to me, and why I'm spending the time that I'm spending on planning issues when the staff is going to be making the majority of the important decisions. So I agree with Eric. I agree that this we need a response from staff relative to his last question regarding how they propose to go forward. Where I might differ with Eric, where I do differ with Eric, is I do not believe that it's an option to bring the matter to the city manager. As I read Chapter 2 of the Municipal Code A4-16, the powers and duties of the city manager, I do not see that they are empowered to decide this issue. I think it can only be decided, if we cannot agree with staff, by the city council. And to that end, I think that we should go directly to the city council. But in the end, I don't want to gloss over what I think is the really just as important aspect of this, and that is we have, as do all cities in California now, a dead design review process. It even calls into question why we have an ARB and what their function would be in this, other than to tell us, here are the objective standards that we think apply. I think as quickly as possible, and I mean very quickly, because we don't know when projects are coming our way, but we hopefully will get state certification of our housing element. And that opens the door for lots of people to come in with projects. We need to sit down in 1 or 2 study sessions and take a look at objective design standards and what I'll call quality of life standards and any other standards that we think are necessary. And as a part of our general plan update process, we need to incorporate them as quickly as possible. To that end, I have some suggestions on what I'd like to see in a staff report that would help us. But, and I'll talk about that at a later point tonight, unless you want me to go into it now. But without reviewing what we have as objective standards and improving the range and depth of those of new standards, we're not going to be in a much better position, no matter who makes the decision. We have lost the ability on a site-specific, plan-specific basis to do a reasonable job of making sure that land development in the city makes sense as we see making sense. And so again, I hope the Planning Commission tonight will ask the staff, please come forward very quickly, even though you can't amend the general plan that quickly, with the your sense of standards that we need to adopt. We should do the same. And with that, again, I will back off until we get to the end of this particular part of the discussion, but I'd like to talk about what I think a staff report needs to contain. Thank you.
Any other comments? So I'll just make a couple of quick notes. I think that Mr. Phillips has made abundantly clear that state law is indeed stripping the Planning Commission of our ability to complete discretionary review of projects. So from my perspective, I'd like to see us dedicate more time and energy to developing those objective standards on which reasonable minds cannot differ. And I think that those standards need to address more than just design standards and more than just architectural things. But I think that there's a variety of topics, but I think that we've recently come to understand that even our affordable housing ordinance could use some fleshing out in terms of what objective standards should be included within it. You know, what is a single family home? How is that categorized? What is a multifamily project? What is an affordable unit? I think we need to start drilling down on those items and really, really start to flesh out those definitions. What is mixed use? What does a mixed use project have to contain? There's many other topic areas, and I think this is going to be a long and protracted process. So I would just encourage us to start focusing on that task, because I think if once we've put truly objective standards in place, that's the public process, right? It's the public process is developing the objective standards. And once those standards are in place, theoretically, there is no difference between whether the decision is made at the staff level or made at the commission level. So those are my thoughts and comments.
Through the chair, if I could respond to some of these comments, there's quite a bit to unpack from what I've heard from the commission. So I'm probably not going to cover everything that I would like to, but I don't disagree with Commissioner Wallace on most of what he has said. But the reality is that SB 330 and the HAA are basically the hand that we've been dealt, and so we need to work within the constraints that we have under SB 330, excuse me, and try to make this process as transparent as possible. And the way that we've been allowed to do so is to adopt objective standards, and those objective standards are done in a public process through the Planning Commission and presumably adopted by the council, if I'm not mistaken. But either way, the Planning Commission will have its say on the matter. So then the only thing that's left are the objective standards to be decided. Those objective standards, as Mr. Phillips has made abundantly clear, there can't be a difference of opinion, otherwise they're not objective. So the consequence, and honestly, my feeling is that the marketplace procedure that we set up for the purpose of having the Planning Commission purview is essentially a failed experiment. It basically set false expectations by the public, that because it falsely implied that the commission had authority that it really did not have. And as such, if we were talking about the backlash, the public backlash, I think a great percentage of that backlash was the result of the public being disappointed in the fact that there really wasn't the authority that we implied there was by setting up this process. And then secondly, it created the issue of whether or not there was exhaustion of remedies, which led to litigation, which led to basically a waste of staff and legal time in fighting off an injunction. And we still have pending litigation now that is essentially that we still have to deal with, even though it's not ripe. So I would like to also just point out that SB 330 does limit us from imposing some of the standards that we have at a local level, or some of the procedures that we have at a local level, if not explicitly, then by rendering some of them essentially unusable. So for example, we now know that we have to comply with a reasonable person standard. So under the HAA, that means if a reasonable person can find that the project complies with general plan and zoning, then that means that the city must deem that project complete. So what happens when, for example, the commission votes 3-2 to find a project inconsistent? Do those two votes constitute a reasonable person? So then under the HAA, the minority wins. Or do we need to have a second vote because the majority has to find that the two no voters are not reasonable people? It leads to an absurd result, and one that we have to resolve somehow. And the only way that I can see to resolve it, and the only way that I know that other cities have resolved that, is to put the decision into the hands of staff. Now, unfortunately, I'm going to have to look at Commissioner Wallace's tiny writing here on this Excel spreadsheet. But I did speak with the city attorney from Folsom, and I did speak with the city attorney from Pleasanton. Both of them are opposed to having the Planning Commission make this decision. Both of them favor putting that decision into the hands of staff. I do understand that the city of Pleasanton, actually that both of these cities, some members of their planning commissions would like to have that authority and reserve it for themselves. I do understand also that the city of Folsom is going to have a tribunal similar to this one, where where a consulting attorney is going to give a presentation and on this so that this can work its way up through their council for a decision on what the policy should be. As for the city of Pleasanton, they have, I understand from reading the citation here in Commissioner Wallace's spreadsheet, that when they talk about the process of, or when they talk about the planning commission participation, what is meant, and I confirmed this with the city attorney, what is meant there is that the planning commission participates in the adoption of the objective standards. Now their planning commission, I believe, feels otherwise, but ultimately that's going to be a decision that their city attorney is going to bring to the council for action on. I did not have an opportunity to look at all of the cities on Commissioner Wallace's list. However, it seems that the common theme is that we are ahead of most of those cities in the process. And so they are asking a lot of the same questions that we were asking months ago. So at this point, they haven't yet reached decisions that we've reached, nor have they experienced what we've experienced through in the SB 330 process. If I don't know if I've left anything out, but if I have, I'm certain that either Eric or Debbie would fill in.
Thank you. Mr. Barr and Ms. Chamberlain, do you have the guidance that you've requested?
We do, and we will be working with the city attorney on the next steps, which I believe will be going to policy committee. Mr. License, is that correct?
Yes, if the commission seeks to have this a policy formalized in order to reserve the authority to themselves on this issue, then we would take this to policy committee.
Do folks have comments in response to that?
Well, let me understand what both of you have said. Is what you're saying is that staff, and I mean by staff I mean city attorney and planning staff, are planning to make a presentation to our city council policy committee about what the city should declare its policy on this particular subject to be?
That's correct.
Okay, all right. I don't have a problem with that, as I've said all along. You know, ultimately, the city council has to make a decision, and the buck stops with them. They're the ones that get the big bucks. So that's fine with me. At least we will have certainty about how the train runs.
And I should qualify that's correct answer to say that that's if the commission so directs us.
Well, if the question is posed to me, I guess my answer to your question would be this. If staff intends to make itself the compliance determination going forward, then I would suggest that the planning commission present this issue to the policy committee preparatory to the full city council, because policy committee, correct me if I'm wrong, it only makes a recommendation to the city council because as two members, it's not a quorum. It can't make decisions. Am I right about that?
Are you talking about the policy committee?
Yes, sir.
The policy committee cannot in and of itself make a decision on the policy. It will refer it to the council if it so decides.
Okay. So that's my druthers. We have three other members of the planning commission here. Our chair is absent tonight for reasons we all know about. So I guess at this point, the question is, what do my fellow planning commissioners feel about how to proceed at this point?
It seems to me that the only option is to refer it to the policy committee. ultimately with the idea that we are going to bring it to the city council. It's a large enough issue that it has to be made at the top, and the planning commission has the right, even the obligation, to make its case and then accept the results.
I would concur on that as well.
I'm of a mixed mind. And the reason for that is that I don't think there are multiple answers here. I don't think there's a choice to be made. I think that state law is what state law is. And we as a commission, we can't win the fight against the state law. So I would rather us and city council focus on adopting objective standards rather than trying to decide who signs the letter and makes the compliance determination. I don't like it any more than anybody else does. I don't like having our hands tied. I don't like a situation where we have a situation where one of our objective standards just didn't get reviewed, right? I mean, if we had a situation where, whoever on the staff, or frankly on the commission, whoever it is that's making the consistency determination makes their checklist and forgets to actually make an evaluation about whether the project does or does not comply with the inclusionary zoning ordinance, it's waived. I don't like that either. But I think that's why we need to put our heads down and really start to focus on what needs to be included with the objective standards. So if there were a vote, I would clearly be outvoted, but that's my feedback.
Can I ask you a question? I don't see what part of state law is violated if indeed the planning commission makes the determination and it occurs within the 30-day period.
I don't think there's a violation of state law that occurs strictly from the planning commission making the determination. There's a risk of a violation of state law when you've introduced this concept that there is discretion in making that determination. Because if the objective standards are truly objective, there is no discretion, there is no decision to be made.
Well, go ahead.
What would be your feeling if the staff made the decision, but only after letting us know publicly what their decision was and giving us an opportunity to discuss it with them, even challenge it?
Well, therein lies the problem. And I think that Mr. License spun this out very nicely. If we have a 5-person planning commission and there's an argument and a dispute amongst ourselves about whether a project is or is not consistent with our objective standards, and 2 people say it's consistent and 3 people say it's not consistent, the reasonable person standard means that the project applicant says, great, my project's consistent. Doesn't matter how you voted. You've got 1 person or 2 persons on the planning commission who made a reasonable determination after looking at the evidence that the project is consistent. Consistency always wins. I mean, that is the problem. That's kind of where we are with state law. It's like the lowest common denominator It doesn't matter if your general plan is inconsistent with your specific plan, the applicant gets to choose which standard applies. It doesn't matter if some people say consistent, some people say inconsistent. If anybody says it's consistent, consistency wins. So we need to, I think that to me, the key really is we have a limited amount of resources in the city. Commission has a limited amount of time. And I think that we would be well served by picking our battles and deciding where we want to focus our energy. And I would rather focus on locking down the objective standards, because the longer we take to adopt objective standards, the more projects sneak through with consistency determinations, because we have too much stuff that is not defined, too much really important stuff that's not defined. In an ideal universe, I'd love to flesh all this stuff out. But we are limited in what we can do.
Well, I do have to claim ignorance with a lot of familiarity with the reasonable person's standard. But I just think that we ought to bring this to the city council, and even they may need to be educated about what the law allows and does not allow. So I would still say bring it to policy and then bring it to the city council.
Well, I agree with Commissioner Marks, obviously, but in response to the chair's comments, twofold. One is, I don't think that developing objective design standards and being the body that makes a decision whether on a particular project, the project is consistent with our standards in the city is an either or situation. As discussed, we basically have one hearing to determine consistency. Obviously, the objective design standard is going to be an ongoing process. So I don't view those as mutually exclusive. The other part that it seems to me is this: what you're saying is that the only way we can have an objective determination of consistency is to have one person make that determination, because if one person makes that determination, by definition, there can't be an argument because one person is making the decision. Sorry, I don't buy off on that. Most of the time, let's put it this way. First of all, most of the time, I think that the staff's determinations on consistency will be accepted by the Planning Commission. I think that the problems we had at Windflower Fields and also Marketplace, I hope will be an anomaly in the process. But you can't judge that ahead of time, and there has to be someone with whom the city rests its decision-making process. The HAA only speaks of the quote local agency, close quote. In the context of housing applications, the quote local agency, close quote, is the city of San Ramon. The city of San Ramon, in its municipal code, has delegated the decisions on planning to the Planning Commission. That's where we are right now. That's where the buck stops for this particular issue. I understand from Mr. Phillips' comments that he thinks it'd be better to centralize that decision-making process and planning staff. I don't agree with him for a number of reasons. But I also feel that, as Commissioner Marks does, that this particular issue is of enough importance to how the city operates and how the city council perceives these projects being disclosed to the citizens, that we need to upstream the decision as to who makes the call to the city council. The first stop is the policy committee. So my view is that we should go ahead, tee up a meeting with the policy committee, present our views, let policy committee make a recommendation to the city council. And at some point, city council will have a public hearing and we'll make our arguments. They make a decision and we're done.
Thank you. Other comments?
When we get to the point when we are looking at objective standards and creating new ones, there is a format that I would suggest that we use in the staff report. And what I would like to do is email that to the staff for their consideration. I'll do that tomorrow, but it's essentially reviewing all of the objective standards that we have in our general plan and zoning ordinance today. Taking a look at the standard, the rationale for the standard, revisions that may or may not be recommended, and citing where those standards can be found. And then attached to that, or as a part of that staff report, laying out what the staff agrees are areas and specific objective standards that they think should be adopted, and we should do the same. We should be encouraged to send our list to them, which they can then put into the overall staff report, and we can get a sort of generalized view of where we're going with objective standards. But we need to do it, I agree, very quickly.
All right, so I think that concludes agenda item 12.1.
Yes, I think we're clear that we will be bringing this item to the policy committee for their recommendation to the council.
All right, so we'll move on to item 12.2, the formation of Planning Commission Ad Hoc Committee for the Transportation Advisory Committee interviews. We are looking for 2 commissioners to volunteer to be part of the Planning Commission Ad Hoc Committee.
Well, since I'm the liaison, I would volunteer unless someone is dying to do it instead of me.
Thank you.
I usually willing to do this, and I will again be willing to do this.
Thank you, Commissioner Kuznick.
It's not on a Thursday. Thursdays are spoken for.
All right, then our last item in agenda item number 12 is the liaison reports. Are there any liaison updates? There are none. Would staff like to provide updates to the commission? List.
Sure. We have a couple of items in the near future. On the 31st, we are having a Chevron Park workshop at the Fountain Room, 6 p.m. start time. We're working on the details of that right now. So formal notice should go out later this week. Also on February 7th, we will have the Marketplace Mixed Use Project coming back. That's again, February 7th. And then a discussion on mixed use definitions and the like.
All right, thank you. And with that, I believe